Hi, this is Suzanne Bouchard, instructor for American Institute for Paralegal Studies. In our estate and trust law class, we've been discussing the popular idea of trying to avoid probate. Is probating an estate important? Is it necessary? Should clients try to avoid it? This lecture includes information we've been studying in our textbook, Administration of Wills, Trusts, and Estates, the 4th edition by Gordon Brown and Scott Myers. Now, when it comes to the idea of avoiding probate, we've learned that non-probate property is real or personal property that's not part of the decedent's estate. Non-probate property is not distributed according to a decedent's will. It's not distributed pursuant to intestate succession statutes in the event there is no will. Non-probate property is not subject to administration of the decedent's estate. It's not subject to a spouse's claims, for example, the elective share, and it's not subject to claims of the decedent's creditors. Now, what are some examples of non-probate property? Well, non-probate property includes real and personal property that is owned and held in joint tenancy with the right of survivorship. It includes real and personal property transferred into a living trust that is registered as owned by the trustee. It includes money placed in a bank account as a Totten trust. Various assets payable to named beneficiaries, such as proceeds of a life insurance policy, employee benefits contracts, annuities, IRAs, U.S. savings bonds, etc. Additionally, a person may remove assets from his or her estate by making gifts of money to others in amounts that do not exceed the amounts set by the IRS. These are just some examples of non-probate property. Now, each of these types of non-probate property goes directly to the named beneficiary or surviving joint tenant by operation of law. So if all of a decedent's property has been removed from the estate, then probate can presumably be avoided. Thus, probating an estate is theoretically not necessary. So why would someone want to avoid probate? Well, we've already mentioned a couple of the reasons. Non-probate property is not subject to a spouse's claims, and it's not subject to the claims of creditors. Another reason someone might want to avoid probate is the time it takes to probate an estate. This is not necessarily an inherent problem of probate. If an estate is very complex, or if disputes arise among beneficiaries, for example, these are some things that may delay the process. People may want to avoid probate in order to maintain privacy. All probate records are open to the public and can be accessed by anyone, so someone who's concerned about maintaining privacy may be sensitive to the fact that probate records are available to the public. A client may want to avoid probate in order to save the costs of administration. Aside from court fees, some of the costs of administration may include, depending on the size of the case, probate taxes, attorney's fees, accountant's fees, that sort of thing. Another reason a person may choose to avoid probate is the possibility of conflicts. Now, when we think of probate conflicts, we normally think of will contests between and among beneficiaries, or people who think they should be beneficiaries. That's certainly a consideration for many people who consider avoiding probate. They want to simply head off any disputes among their loved ones over their estate. There's also the potential for disputes regarding the decedent's domicile when the estate contains property in more than one state. So minimizing these conflicts is one more consideration for clients who choose to avoid probate. These are a few of the reasons estate planning clients may wish to avoid probate. The bottom line is that if the client successfully places all of his or her property into non-probate assets, then probate may be avoided. Now, whether or not this is a good idea will depend on the facts of the case, the size of the estate, the assets owned, those sorts of considerations. And a paralegal working in an estate planning or probate law practice will need to be familiar with the differences between probate and non-probate property, and also be sensitive to the reasons why clients may wish to avoid probate. If you're not currently a student at AIPS, and if you'd like more information about careers in the law, please visit our website at aips.com.